Hello, law students and legal practitioners. Today, we will analyze the case of ARG versus AMP. NPC Case No. 22-257 and decided by the National Privacy Commission in 2024. Let's begin. Here are the doctrines of this case. Processing of personal information is lawful under Sections 12(f) and 13(f) of the Data Privacy Act of 2012 when it is necessary for the legitimate interests of the personal information controller or for the establishment, exercise, or defense of legal claims, provided that such interest does not override the fundamental rights and freedoms of the data subject. A person who determines the purpose and manner of processing personal information is considered a personal information controller, PIC, under the DPA, even if the person did not originally collect or store the data. Requesting, obtaining, photographing, or using documents containing personal data constitutes processing within the meaning of the law. Daily time records of government employees generally fall outside the scope of the DPA under Section 4(a) and (b) when the information relates to the position, functions, or services rendered by the public officer. Even where personal information is involved, processing may still be lawful if supported by legitimate interest or necessity for legal claims, subject to compliance with proportionality and purpose limitation principles. I will now narrate the facts of this case. Complainant Dr. ARG and respondent Dr. AMP are both physicians at a government hospital. Dr. ARG is the head of a department, while Dr. AMP is a consultant in the same department. Beginning in 2020, Dr. ARG discovered that Dr. AMP had been collecting copies and taking photographs of the daily time records, DTRs, of consultants in the department. According to Dr. ARG, the department's administrative assistants informed her that Dr. AMP had repeatedly requested copies of departmental records and had taken photos of the DTRs. These claims were supported by screenshots of message exchanges between the administrative assistant and Dr. AMP, as well as sworn statements presented to hospital authorities. Dr. ARG raised the issue internally and consulted the hospital's data protection officer, after which a formal complaint was submitted to the hospital's Data Privacy Committee. 13 consultants later signed a letter complaining about Dr. AMP's actions. Mediation proceedings failed, prompting Dr. ARG to file a complaint before the National Privacy Commission, alleging violations of Section 25, unauthorized processing, and Section 28, processing for unauthorized purposes, of the DPA. Dr. AMP admitted that he obtained copies and photos of the DTRs but argued that he did so upon the advice of a Civil Service Commission officer in preparation for filing an administrative complaint against erring doctors who allegedly falsified time records. He asserted that the DTRs were necessary evidence to establish his legal claims and that such processing was justified under Sections 12(f) and 13(f) of the DPA. Here are the issues resolved by the National Privacy Commission. Issue 1. Whether Dr. AMP processed Dr. ARG's personal information within the meaning of the DPA. Yes, Dr. AMP processed personal information. Under Section 3(j) of the DPA, processing includes any operation performed upon personal information, including collection, retrieval, consultation, and use. By requesting, receiving, and photographing the DTRs, Dr. AMP exercised control over the personal information and determined its use and purpose. The NPC held that these acts constitute processing. Further, Dr. AMP qualified as a personal information controller because he determined why and how the data would be used, despite not being the original custodian of the records. Issue 2. Whether the information contained in the DTRs is personal or sensitive personal information covered by the DPA. The DTRs contain personal information but are largely excluded from the scope of the DPA. Section 4(a) and (b) of the DPA excludes information relating to the position, functions, and services rendered by government officers and employees. The NPC ruled that DTR entries, such as time of ingress and egress, name, position, and signature, relate directly to Dr. ARG's functions as a government doctor and are therefore excluded from the scope of the DPA. Even the notation, quarantine leave, was held insufficient, by itself, to constitute sensitive personal information absent detailed health profiling or stigmatizing content. Issue 3. Whether Dr. AMP committed unauthorized processing under Section 25 of the Data Privacy Act. No, Dr. AMP did not commit unauthorized processing. To establish unauthorized processing, There must be proof that the processing was done without consent and without lawful basis. Sections 12(f) and 13(f) provide lawful bases where processing is necessary for legitimate interest or for the establishment, exercise, or defense of legal claims. The Commission found that Dr. AMP processed the DTRs to prepare an administrative complaint before the CSC concerning alleged falsification of time records. This constituted a legitimate interest in processing necessary for the establishment of a legal claim. The processing was relevant, proportionate, and directly related to the intended legal purpose, and thus lawful under the DPA. Issue 4. Whether the complaint should be dismissed. Yes, the complaint was dismissed for lack of merit. Where lawful basis exists and requisites of unauthorized processing are absent, no violation of the DPA may be sustained. Since Dr. AMP had lawful basis under sections 12(f) and 13(f), the third element of unauthorized processing was lacking. Accordingly, the NPC dismissed the complaint without prejudice to other civil, criminal, or administrative remedies. Thank you for listening and happy learning. See you again for our next case discussions.